Ed Sheeran turned the courtroom into a private concert. I got good news, guys. Ed Sheeran is not quitting music forever. Whew. I mean, I got shivers. That was a close call. I mean, or was it? Let's break down the copyright trial of Ed Townsend's estate versus Ed Sheeran and find out just how close we came to losing Ed Sheeran's perfect vocals. Now, don't forget to lawyer up with America's Attorney by subscribing. But for now, let's just jump in. This lawsuit was filed way back in 2018. In the 30-page lawsuit, the estate of Ed Townsend, co-writer of Let's Get It On, accused Ed Sheeran and company of copying various elements of the 1973 classic, including, but not limited to, the melody, rhythms, harmonies, drums, bass line, backing chorus, tempo, syncopation, and looping. I mean, look, I'm not a music guy.
He used to call me on my cell phone. Squash the bug.
But gee whiz, what's left of a song after you take out all those elements? Just the lyrics? The lawsuit does provide timestamps for the alleged copied music by stating that the same backing pattern in the first 7 seconds of Let's Get It On can be heard in the first 6 seconds of Thinking Out Loud. The lawsuit then claims this same pattern is heard throughout the rest of both songs, making them too similar for the estate's comfort. We then get a couple of paragraphs in the lawsuit comparing chord progression, bass lines, harmonic rhythm, vocal melodies, and tempos. Now, you all know about all that stuff. In paragraph 66, we get the first mention of the now infamous Thinking Out Loud, Let's Get It On mashup that Sheeran performed at concerts. I guess Townsend's estate didn't think that this was the perfect duet. When asked about this mashup in trial, Sheeran stated that he would be an idiot to perform the song live in concert if he were guilty of stealing from it. But being an idiot is hardly a great defense though, since the world is like filled with idiots. The actual law that Sheeran is accused of breaking is obviously willful copyright infringement, also known as 17 U.S.C. Section 102. The plaintiffs apparently wanted Ed to make it rain because they assessed the damages in excess of $100 million. The lawsuit then requested a trial by jury, which, as we know, was granted. So that was 5 years ago, and the week-and-a-half-long trial began on April 24th, and it ended last Wednesday. So let's go over some of the highlights from that trial. As we know, the plaintiff's main argument is that Sheeran stole parts of the composition of Gay's song to write Thinking Out Loud. In an attempt to prove this, they brought in a music expert who testified that the song sounded very, very similar to him, which sounds like an airtight claim from a music expert, right? Dr. Stewart also testified that in his view, the songs had the same harmonic rhythm and similar melodies. Now we're sitting here like,
whoa, an expert witness? How can Sheeran beat that?
well, obviously by getting his own expert witness. So to counter Dr. Stewart's points, Sheeran's team brought in Dr. Ferreira to the stand. Now, Dr. Ferreira, who is something called an expert musicologist, which is a thing, brought in his own examples of other artists' songs that share similar chord progressions and rhythm as both of the songs involved in this trial. Here's the catch. All of Dr. Ferreira's examples were songs released before Let's Get It On. Now, I don't want to linger on this point too long, but if Townsend Estate is coming in and saying, these are my chords and you copied them, and Sheeran says, oh, not so fast, here are the same chords, and these are some songs that predate yours, then Townsend's estate doesn't own the music and has no viable copyright claim. But whether this is actually a good trial strategy, I'll have to address that in a couple of minutes. Now, in order to prove that the chords are only similar based on the fact that they are the same building blocks that every songwriter uses, Sheeran took to the stand twice, not only to speak, but also to play his guitar. A live concert for the jury! Objection! No, lucky them. The plaintiffs and the defense then laid out their closing arguments before releasing the jury to start thinking out loud in the jury room. Nailed it. Also known as jury deliberation, the plaintiff's side reminded the jury that Mr. Sheeran's celebrity should not weigh in their final decision. And they addressed what they considered to be their strongest pieces of evidence. Number one, their music expert's testimony, and two, the video of Sheeran performing a medley of the two songs in concert. This lawsuit was being closely watched by the music community because many believed that it had the potential, at least, to open the floodgates of copyright lawsuits against artists. The plaintiffs' lawyers downplayed this angle by telling the jury that their aim was not to damage creativity, but simply to get credit and discourage theft. In the defense's closing arguments, Sheeran's attorney claimed that the plaintiffs had been unable to meet the burden of proving their allegations and reminded the jury of their own expert witnesses' testimony, denying the similarities between the two songs. So what elements are there to proving a violation of copyright law? Well, what factors would the jury have to consider in making their decision? Really, there's just three main elements: ownership of a valid copyright, the copying of some constituent parts of the music that are original, and of course, some monetary damages, losses, or some other reason to involve the court system. Now, in the Ed Sheeran trial, there really was no contest that the estate of Ed Townsend owns the song Let's Get It On. And also, there was no real contest that Thinking Out Loud was a major financial success for Sheeran. So the trial was really about whether Sheeran wrongfully copied some constituent parts of the music in a way that was over the line. What line, you might be asking yourself? That's a great question, actually. Copyright trials are notoriously fact-specific because there's a judgment call involved in each instance of alleged copyright infringement. I mean, unless it's so obvious that no one can dispute it. But some constituent parts, that phrase, some constituent parts, does not mean a note-for-note copy. That would be too easy. But what are the constituent parts of music? You got notes, instruments, cadence, volume, the passing of time. I mean, look, this video here, this is not a music theory class. But if you find yourself on a jury in a case about music theft, that trial will end up being a crash course in music theory. Because in the end, it's about splitting hairs. Obviously, under a microscope, you can say that any two things are different. And from a far enough away distance, you can say that any two works of art are basically the same. The sweet spot is somewhere between a microscope and a telescope, and that's where you want the jury to be. Now, in the Sheeran case, he convinced the jury to stand close enough to the music to see, aka hear, the differences. There are only so many notes, there are only so many chords. Lots of music sounds like similar, but too similar? Well, apparently not this time. We shouldn't be surprised that Sheeran won this case. Thinking Out Loud was written in 2014. And if it took the Townsend estate 4 years to hear the similarities, I mean, do I need to say more? And there's also this. If Ed Sheeran's lawyers thought for 1 second that he might lose this case, you better believe that they'd have instructed him to either immediately pull the song from every spot that he could pull it from, or otherwise prepare for a massive judgment. But before I go, I want to say this. If Sheeran's defense is that Townsend's estate doesn't own the chords because they were used in other songs prior to Let's Get It On, then he's potentially opening himself up to a trial from the people who do own those chord progressions that he's saying that the Townsend estate stole from when they wrote Let's Get It On. All this led us to the jury verdict that we got. After only 3 hours of deliberation, the jury decided that Ed Sheeran did not steal the key components of Ed Townsend and Marvin Gaye's song. So, musical freedom lives to see another day, and I'm sure that Ed Sheeran is feeling a lot happier. Now, 3 hours is not long for jury deliberation. I mean, they could have spent that time just listening to really good music. I mean, if they could find any. But now it's time for you to jump in with your pro se opinion. If you've heard both of these songs, which I know you have, I want to hear from you right now. Are you suspicious of the similarities, or do you agree with the jury verdict? Let me know down below in the comments, and stick around here by lawyering up with me, America's attorney. I will be back soon, and in the meantime, check out these videos.